Hi, this is Jim Filippi coming to you from the Filippi Law Firm. I'm here to talk to you today about how joint ownership is not a good way to plan your estate, and that estate planning is still very critical for what you need. So sometimes I'm asked, can I just avoid having an estate plan by just adding my loved ones, whomever I plan on passing my assets to, adding them to title, make them a joint owner of my assets? Say it's a house, you add them to joint ownership on your house. So if something happens to you, automatically they get that asset. And in certain situations that works. However, it's very limited. So that if, say, you and your spouse buy a house together and you own that jointly in a form of title that's called joint tenancy or community property with right of survivorship, they both operate the same when someone dies, meaning that if one of the owners dies, their interest basically disappears and goes to whoever the survivor is, and now the survivor has that property in its whole. And the thought process here is some people decide that, I'm going to use the benefits of that joint ownership, and I'm going to go ahead and just add my kids to title as joint owners so that, as people die from that group, whoever's left over gets the whole of the property. And that sounds fantastic because that's a relatively cheap way of passing that asset to whomever you decide. The problem is that if everyone dies, there's no plan for what happens next. And in that situation, that house will go into probate. If you don't have an estate plan in place, the state has one for you in the probate code, and now the courts and the state decide what happens to your assets. And my experience has been that not a lot of people get very excited about letting someone else, like the state, decide what happens to their assets. There's also some tax benefits to having your house in a trust. And this is not tax advice. You should consult with an attorney about this or a CPA because tax situations are different for all of us. And the tax codes change quite often, so depending on when you view this video, we could have had a tax law change. But as we sit right now in 2021, there's a thing called the step-up in basis, and this is just dealing with capital gains tax. So when you buy an asset, you buy it at a certain price. So say you buy a house for $100,000. And throughout the years, your house appreciates in value, and now it's worth $400,000, and you decide to sell it. The difference between that $100,000 that you purchased it for and now the $400,000 you're selling it for is $300,000. And the government sees that as what's called capital gains. And unless you have an exclusion, and we can talk about taxes all day long, but unless you have an exclusion, you're going to be taxed on that $300,000. And it's going to be a certain percentage, and depending on the amount of time you've had that asset, it could be anywhere from 15 or more percent. If you have that asset in a trust, it allows for what we call a step-up in basis, just meaning that original value or the original price you purchased the house at is stepped up to the value of the day you die. So that if those people that you give your house to decide to sell the house after you die, their gain isn't going to be based on that $100,000. It'll be based on whatever value it is at the time of your death. So that spread is far smaller, and thus the taxes that you pay is far lower, if anything at all. And so you don't get that benefit if you put your loved ones on title and pass the property to them, because they gain ownership of that property the day you put them on title. So there's no step up in basis. They're on the hook for the full, whatever amount that is, whatever the spread is, they're on the hook for the full amount when it comes to capital gains. Again, unless they have some exclusions. We're not going to talk about exclusions in this video. Please talk to a CPA when it comes to tax situations for yourself. But realize that there are some very big tax benefits in having your house in a living trust rather than just using joint ownership as a way of dispersing your assets when you die.